failed to demonstrate compelling reason to warrant the detention of the respondent for 21 days or at all. The reasons advanced are either unsupported by evidence, speculative, or unrelated to the necessity of detention. In that case, the court makes the following orders in the interest of justice. Number one, the application dated 23rd June 2026 seeking orders to detain the respondent for 21 days is hereby dismissed. The respondent shall be released on bond of Kenya shillings 100,000 with one surety of similar amount. In the alternative, and without prejudice, he will be released. Respondent shall be released on a cash bail of Kenya shillings 50,000. And in that one, I also add that he also provide us with a contact person who shall also act as a surety, in as much as it's a public figure. The respondent shall report to the investigating officer every Monday, despite his busy schedule as a member of parliament, Wednesday and Friday, or they may agree with the IO until the expiry of the 21 days that was sought. The matter will be mentioned after the lapse of the 21 days for further orders. I believe that will take us to 13th or 14th, Chemutai? 14th. So 14th. Thank you.
Thank you for that. We pray.
I believe that the quorum is still the same.
Yes, Your Honor, the quorum is as before.
Just Minitambur, our colleague Minitambur joined us. She's present.
Okay.
But the rest of the quorum retains as it was.
Okay. So the respondent, Honorable Mutai Kiprono Alfred. Well, you are there. I believe English will be appropriate in the circumstance. So this is a ruling in respect of a notice of motion application dated 23rd of June this year, brought pursuant to Article 49, Subarticle 1F and G of the Constitution of Kenya 2010 and other enabling provisions of the law, which the applicant through the Directorate of Criminal Investigation, Kuresoi, Note 6 custodial orders to detain the respondent for a period of 21 days pending completion of investigations. The application as drawn is premised on allegation that the respondent, jointly with others not yet arrested, is under investigation for offense of arson contrary to Section 332A of the Penal Code, malicious damage to property, contrary to Section 3391 of the Penal Code, and assault causing actual bodily harm, contrary to Section 251 of the Penal Code, allegedly committed on 19th of June 2026 at Umoja Tuluet Senior School during an event organized within Crusade North Sub-County. It is alleged that a motor vehicle registration number KDQ 155G, an Isuzu minibus, was set ablaze, and that other motor vehicles, including a government vehicle registration number KGB 253Z and a Toyota Prado registration number KDV 444A, were maliciously damaged. Further, it asserted that 2 persons sustained gunshot injuries and are admitted in hospital in critical condition. The grounds in support of the application, as well as the supporting affidavits found by Inspector Polycarp Magai, indicate that the continued detention is necessary to enable the investigation agency conduct valuation of the damaged properties, recover the respondent's firearm for ballistic examination, record statement of witnesses allegedly admitted in hospital, carry out identification parade, prevent interference with witnesses, facilitate medical examination of victims, and afford the investigation time to carry out comprehensive investigations. The application was presented by the Learned State Counsel, Ms. Boyon, through the investigating officer, IP Inspector Polycarp Magai, and was vehemently opposed by the Learned Counsel, Mr. Karanja, Mr. Guto, and Mr. Biko of the respondent. At the hearing At the hearing, the deponent, Inspector Polycarp Mutai, was extensively cross-examined. In the course of that cross-examination, he candidly stated that at the moment, the investigators had not made a determination to charge any person, notwithstanding the prayer to detain the respondent for 21 days. He further struggled to explain how the continued detention of the respondent will facilitate valuation of the allegedly destroyed motor vehicles, and was unable to satisfactorily demonstrate how the respondent will interfere with witnesses. It also emerged that the police had already assessed the respondent homestead and effected arrest of other persons without any hindrance while the respondent was not in custody. The investigating officer was also unable to justify why evaluation was to be undertaken by a valuer from Nairobi as opposed to Nakuru. On the issue of recovery and surrender of firearm, he referred to a prayer that was not contained in the application, and upon being pressed, was unable to demonstrate that such a prayer really existed. Notably, despite being a police officer, he could not adequately explain the legal process governing surrender of a licensed firearms. With regard to the alleged victims admitted in hospital, the officer confirmed that he had no documentary proof before the court to establish the existence of such victims or their injuries. He further confirmed that the respondent had been summoned by the County Criminal Investigation Officer, that's the CCI. Sorry for my S and C's. I think it's a mother tongue influence. Voluntarily presented himself, recorded a statement, and was thereafter placed in custody, leading to his arraignment before this court. On the issue of identification parade, he considered that the respondent is a public figure, being a member of parliament and well-known within Nakuru County, thereby casting doubt on the probative value of any proposed identification parade. He declined to disclose. In submission, the learned counsel, Mr. Karanja, for the respondent, opposed the application and relied on the decision of Michael Rotich versus Republic 2016, where the High Court emphasized that continued detention is a limitation of the constitutional right to liberty and can only be granted upon demonstration of compelling reasons. He also submitted that no such compelling reason had been advanced, arguing that the grounds cited by the applicant, including valuation, ballistic examination, identification parade, and the alleged hospitalized victims without supporting documents, did not meet the constitutional threshold. Counsel further submitted that the respondent, being a sitting member of parliament, will suffer prejudice if detained for 21 days, as this will affect his representation of his constituents. Mr. Biko, in supplementing the opposition, argued that no charge sheet had been presented to demonstrate the nature of the allegation confronting the respondent. He pointed out that the police had already assessed the respondent resident and conducted operations without interference, hence the allegation of possible obstruction was unfounded. He also criticized what he described as a growing trend of using custodial detention as a political tool, terming it discriminatory. In reply, the learned counsel, Ms. Boyon, urged the court to find that the burden under Article 49 had been discharged and the orders sought were necessary to enable completion of investigation. I've carefully considered the application, the supporting affidavit, the oral testimony of the investigating officer under cross-examination, the rival submission by the learned counsel, and the starting point is Article 49, Sub-Article 1F of the Constitution of Kenya 2010, which guarantees an arrested person the right to be brought before a court as soon as reasonable possible and not less than 24 hours. Under Article 49(1)H, which secures the right to be released on bond or bail on reasonable condition unless there are compelling reason not to be released. Continued detention prior to charge is therefore a serious limitation of the right to liberty and must be justified by cogent, specific, and verifiable reasons. The jurisprudence in this respect is Republic vs. Ahmad Abul Fatih Mohammed and another 2018 EKLR, and it's clear that burden lies on the prosecution to demonstrate compelling grounds to warrant curtailment of liberty. In the present case, several concerns arises. First, the IO, that is Inspector Mutai, expressly confirmed that no decision has been made as to whether the respondent or any other person will be charged. This raises question as to the basis upon which this court is being asked to deprive a citizen of liberty for 21 days. Secondly, the ground advanced in the application are not supported by cogent evidence. There is no documentary evidence to confirm that alleged hospitalized victims, their injuries, or their inability to record statements. Sorry. The claim that an identification parade is necessary is undermined by the admission that the respondent is well-known public figure. Thirdly, the assertion that the respondent will interfere with witnesses remains speculative. No specific witness can be identified. No factual basis has been laid to support that apprehension. On the contrary, it's evident that the police have already conducted operations, including assessing the respondent's homestead without obstruction. Fourthly, the prayer relating to recovery of firearms and ballistic examination is not anchored in the application, and if it were, the IO was unable to explain the legal procedure relating to licensed firearms. Fifthly, the justification for valuation of damaged property does not logically require the continued detention of the respondent. Similarly, the explanation as to why such valuation must be undertaken by a valuer from Nairobi rather than locally was unsatisfactory. The court must guard against converting pre-charge detention into a tool for fishing expeditions or speculation. The Constitution demands accountability and precision in limiting fundamental rights. In Republic versus Danson Mungunya and another 2010 EKLR, the court held that mere suspicion, however strong, cannot justify deprivation of liberty. It failed to demonstrate compelling reason to warrant the detention of the respondent for 21 days or at all. The reasons advanced are either unsupported by evidence, speculative, or unrelated to the necessity of detention. In that case, the court makes the following orders in the interest of justice. Number one, the application dated 23rd June 2026 seeking orders to detain the respondent for 21 days is hereby dismissed. The respondent shall be released on bond of Kenya shillings 100,000 with one surety of similar amount. In the alternative, and without prejudice, he will be released. Respondent shall be released on a cash bail of Kenya shillings 50,000. And in that one, I also add that he also provide us with a contact person who shall also act as a surety, in as much as a public figure. The respondent shall report to the investigating officer every Monday, despite his busy schedule as a member of parliament, Wednesday and Friday, or they may agree with the IO until the expiry of the 21 days that was sought. The matter will be mentioned after the lapse of the 21 days for further orders. I believe that will take us to 13th or 14th, Chemutai? 14th. So 14th. Thank you.
Thank you for that. We pray